On Thursday, July 25th, 2024, the Ashley Benefield trial continued with day 3 of testimony. And on day 3, the jury heard from just 3 more witnesses before the state rested its case. And in between, there were a number of issues that came up outside the presence of the jury. This included some evidentiary issues, as well as a situation where one witness was talking with the media, and a question as to whether a juror may have heard some information about the case during a lunch break. And ultimately, at the end of the day, when the state rested, the judge heard the defense's motion for a judgment on acquittal. So, at this point in the trial, where do you stand? Do you think that she might be guilty of murder, or is there enough to suggest that she had a good self-defense argument? Watch until the end, and then I want to know what you think. Let's get into it. Okay, so like I said, at the beginning of the day, there was a little bit of out-of-court behavior that they needed to discuss. In fact, there were 2 matters to go over without the presence of the jury. One was an apparent report to a bailiff that someone saw Eva Benefield, Doug Benefield's adult daughter, talking with the media. Now, as you recall, she already testified on day 1. And typically when we see a witness testify early, particularly a family member of the alleged victim, they get released from their subpoena so that they are free to watch the proceedings and talk to basically whomever they want, aside from witnesses who have yet to testify. However, in this case, a good portion of these witnesses have actually not been released from their subpoenas after they finish testifying, because one or both of the legal teams has decided that they might want to recall that witness for some kind of rebuttal later in the trial. So even when asked to step down at the end of their testimony, they still can't talk with anyone about their testimony, and they can't watch the proceedings. The only exception for Eva, as opposed to other witnesses in this trial, is that she, actually like her uncle Tommy, is allowed to be in the courtroom and watch the rest of the trial as interested family members. But they still are not allowed to talk to anyone about their testimony, to include the media. So anyway, during this proceeding, Eva was asked to come back up to the witness stand and to testify as to what happened with that member of the press and what she told them. She said she was caught off guard by them in the courthouse hallway and that she was feeling very emotionally distressed by hearing all of this testimony about her dad. And she said, "I didn't talk at all about my testimony. All I said was how I felt about the overall circumstances right now." Now, all of this is reasonable, right? She is the daughter of the alleged victim. Regardless of what may have happened between him and Ashley Benefield, this is still her dad after all. And the court did note that the media is not supposed to be approaching any of these people in the hallways of the courthouse. Now, going further into the subject, she also was asked about any sort of social media posts that she may have made. And she did say that she had posted about the trial generally a few times since she had testified. And here, defense attorney Neil Taylor started to ask to look at Eva's phone about this issue, which prosecutor Suzanne O'Donnell objected to as an invasion of privacy, and Judge White did agree very quickly. Judge White basically said that the defense was trying to get into a fishing expedition with this. Now, Taylor tried to argue that he needed to get information about these social media posts to find out the extent of what happened, but I think this is maybe just a sign of an older attorney who doesn't really understand social media. If these were somewhat private communications that we were talking about that were at issue, I could understand him needing to see her phone. However, when it comes to social media, anyone can hear what Eva said and just instantly go, okay, I can just look at social media and see what she said. It's entirely unnecessary to look at Eva's phone because any relevant information on the subject is going to be readily available from basically any other device. So ultimately, Judge White cut the whole inquiry off, and he said that he wasn't going to make a decision, although he had heard enough at the time. At this point, he wasn't going to make a decision as to whether or not she could be recalled as a witness later. But he said if one of the legal teams decides later that they want to recall her, he will revisit the subject. Anyway, the other matter that they needed to go over was from a letter that the court received from a law firm that said it represented a member of the media. And this letter said that the journalist was at a nearby restaurant at the lunch break and saw that one of the male witnesses was there. The journalist further said that there was TV coverage about the trial being shown at the restaurant and that they could hear a couple people talking about the trial within earshot of this juror. So Judge White had to call in each juror one by one and basically ask them all the same things. Do you know anything about this? And have you come across anything that impacted your knowledge of the information in this case? And so one by one, each of them basically said, nope, nothing to report on that. So it didn't really turn into anything substantial, but nonetheless, I figured it was worth mentioning here. Okay, so anyway, then day 3 got on with the substantive testimony, and here they picked up with the state's 17th witness, Sergeant Brian Quiles. He is an officer with the Technical Services Unit from the Manatee County Sheriff's Office. And so this testimony was all about the Celebrate extraction from Doug's and Ashley's phones. And most of this was primarily to go through text messages exchanged between Doug and Ashley throughout the course of their relationship, as well as a couple photos and a video. This testimony ended up taking up a big portion of the day, but this was largely because they needed to send the jury out multiple times so that the two sides could hash out the admissibility of some of these things. Now, aside from that, I don't know that these texts, photos, and videos really move the needle all that much for the most part. Now, don't get me wrong. I know why the prosecution wanted to introduce most of this stuff. It was to show that when Ashley and Doug were interacting one-on-one, they were actually doing very well. There was nothing suggesting that Ashley was in any kind of fear, but rather that she had some relative comfort with him. And so this fits into the prosecution's theme that Ashley was one way when she was with Doug and another way when she wasn't. But I guess the reason why, to me anyway, this didn't seem to move the needle all that much was because it doesn't seem to be in dispute that Ashley changed her demeanor depending on whether Doug was there with her. The place where the two sides diverge on this matter is the reason for that compartmentalization, if you want to call it that. So, for example, when the prosecution showed that Doug would regularly send Ashley screenshots of Bible verses and that the metadata would show that Ashley would love or heart that picture in iMessage, it doesn't seem to tell us anything that we don't already know at this point. And these texts, to me anyway, didn't seem to give any insight on the question of the reason for the difference in her behavior. Was it her being duplicitous and malicious? Or was it her being a DV victim in survival mode? These texts didn't really help to illuminate the answer to that question. However, there was one thing that came in during Sergeant Quiles' testimony that could help to give a better picture on this particular question of whether she was actually in fear of Doug when she was present in person with him. And that was one bit of video footage that came in at trial. This video shows Ashley, Doug, and Alicia sitting in a restaurant with Emerson off camera and the three adults playing the game Heads Up. If you're not familiar, this is a game app that you can download on your phone where one person is supposed to guess the term and the rest of the people present are supposed to give hints that don't actually use any of the words in the term. And there's a timer to give a guessing deadline. So here's a clip of them playing Heads Up in the restaurant where Doug was supposed to be the one guessing the term.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real?
Second part.
Real?
Working mother. Not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum.
people literally refer to like great.
Oh no, it's running out of time.
I live in a
House.
and
Real house. White.
So put together.
Housewives of.
Real housewife.
Oh, real. Oh.
I will say, this evidence does help the prosecution here. You can see that everyone here does look pretty comfortable, even if some of the guessing communication is a little awkward between them. The way that Ashley throws her head in laughter after she says, "You live in a," and he guesses slum, looks very comfortable. Now, I'm sure people who are pro-defense, particularly people who have experienced DV themselves, might point out, okay, but there are reasons for her to be more comfortable in this environment than, say, in some others. She's sitting next to her mom, for example. She's in a public place, and there are a bunch of other people around. And these are things that can cut down a DV victim's anxiety in the moment. And this is a different situation than when it was just Doug and Ashley in the house at the moment that she shot him. And all of that is entirely possible and understandable and reasonable. But to credit the prosecution, so far, this is the only video footage that the jury has seen of the two of them interacting in person. And video evidence like this can make a powerful impression on people, especially if there's nothing else that the jury can view with their own eyes to show a different perspective. So like I said, this is helpful to the prosecution. Anyway, then the defense got up for cross-examination. And here the defense emphasized that Sergeant Quiles can't decipher the meaning behind any of these text messages or images between Doug or Ashley. And here Sergeant Quiles responded, yeah, that makes sense. For example, the defense attorney said, okay, so you saw Doug sent Bible verses. And he said that doesn't necessarily mean that he was a religious or devout man, right? That just means that he was sending her Bible verses. And like I said, understandably, the witness agreed. He was like, yeah, I don't actually have any context to any of this. And that's an important point for the defense because the Bible verses in particular could mean one of two things. On the one hand, it could be that Doug was in fact a religious or devout man and that he turns to religion during times of hardship. There are plenty of people out there who do this and do this properly and who express that devotion particularly during times of hardship because they find it most useful to help them get through. Absolutely 100% valid interpretation. But at the same time, you can also look at it through the lens of a DV situation. Another perfectly reasonable explanation here is that he's using religion as a means of control. And so I'm sure that there are bound to be comments on this recap from people who have survived DV relationships where religion was used precisely for that purpose. And that's because the reality is religion is a powerful tool. It has the power either to lift people up into enlightenment or to help carry them through hardship. Or on the other hand, it also has the power to oppress people. And all of that depends on how humans choose to use it. So looking back at the cross-examination, Taylor didn't make this point expressly, but I'm wondering if the defense plans to introduce a DV expert at some point to point this out. Anyway, then the judge sent the jury out again to go over a couple arguments over some things that the defense wanted to get in on cross-examination. The first was apparently a series of WhatsApp messages that the defense wanted to introduce through this particular witness that they said would help to show Ashley's state of mind, specifically her apprehension towards Doug due to prior specific instances of violent aggression. However, Judge White kept these out for now because he said that these texts are example of character evidence. And character evidence is generally kept out unless there's some kind of an exception that can bring them in. And here Judge White said that there is an exception that can potentially bring them in, but the defense has to lay a particular foundation first. And that foundation is laid with some kind of evidence showing that in the moment where the defendant says that she used self-defense, the alleged victim did something that essentially triggers this memory of this prior violent encounter. And so Judge White said that the defense has not yet laid that foundation with evidence. Now you might be thinking, but wait a minute, the jury heard in opening statements when the defense described the way that Doug was crouching in some kind of a fighting pose like he was about to attack Ashley. But to that I say, remember that what the attorneys say in opening statements and closing arguments is not evidence. Evidence has to come out during the case in chief. And although the jury has heard that they will hear evidence of this, at this point in the trial, they have not yet heard it. So it is up to the defense to lay that foundation with some kind of testimony or some kind of evidence. Now, what about this other part, the requirement that there be a showing of a triggering behavior by the alleged victim? I can understand some people looking at that and saying, well, that's not fair. A DV victim is going to have all of those past violent behaviors in their head all the time, so they're always going to be afraid of their abuser. Well, this is where things get a little bit more nuanced when we're talking about DV and a self-defense argument for murder. Because if you think about it, two things can be true at the same time. A criminal defendant can be a victim of DV and they can also murder their abuser. Or, on the other hand, of course, the DV victim can have killed their abuser in self-defense. So what is the difference here? The difference is what was actually in the mind of the DV victim in the moments leading up to the death of the abuser. And by the way, I say all of this not to say that I am concluding right now that Doug was an abuser. I have my suspicions based on what we've heard so far, and I did mention on day one that there has been some corroboration of the defense's argument that Doug abused Ashley, particularly through Eva's testimony where she admitted to having seen holes in the wall and the ceiling. I do still have some questions about the circumstances around how those holes got there before I feel like I can reasonably make conclusions about them, but the inference definitely is there. So questions are like, were those isolated incidents that they were able to move past, or were they recurring? So those are questions that also should be answered here to help inform Ashley's mental state. They were getting closer and closer to September 27th, 2020. So anyway, all of that is to say that I haven't made any firm conclusions as to whether Doug was or wasn't an abuser at this point. That may frustrate some people who have made firm conclusions, but quite honestly, I don't really care. As I always say, everyone has a right to their own perspective, and everyone has a right to come to conclusions at their own pace. And by the way, the jury is supposed to refrain from making conclusions until the very end of this case themselves. So keep that in mind too. back to the point at hand. What matters most in a self-defense case is DV or no DV. What was in the mind of the defendant in the moments leading up to the killing of the alleged victim? DV has been such an important focal point in this case so far precisely because it can potentially help to inform so much about the defendant's mental state here. Was Ashley in perpetual fear of Doug, or was she making this all up? But even if she was in perpetual fear, did she in that moment have a reasonable fear that Doug was about to cause her serious bodily harm or even to end her life? Because, as a hypothetical, you could have a DV situation where the abuser is sitting on the couch, playing a game on their phone, or, just otherwise minding their own business. And unless there's something about the situation that suggests the beginning of a pattern of abuse that has played out before, like the abuser is maybe playing on his phone, but starting to get frustrated and exhibiting signs of anger that in the past have led to the defendant's serious bodily harm. If otherwise the abuser is just sitting there peacefully, there's nothing here that suggests that there is a dangerous situation for the defendant. So in that situation, it would be much harder for the defendant to make a valid self-defense argument, even if there has been a past of very scary behavior by the alleged victim. Basically, what I'm getting at here is that the fact that there's a history of DV between the two of them doesn't necessarily mean that the defendant, as an alleged DV victim, can just kill the abuser at any point in time. There has to be a showing, nonetheless, that in that moment, the defendant had a reasonable fear that they were about to be seriously harmed or worse. And like I said, evidence of DV does go a long way to help make that showing. But it really doesn't get the defendant all the way there. There needs to be just a little bit more. And so, bringing this all the way back to the WhatsApp messages that the defense was trying to get in. This is related because the defense is going to need to make that showing of a trigger event from the moments leading up to the shooting that will allow for these messages to be properly let in. So for now, the defense wasn't able to get the WhatsApp messages in, but Judge White said that they might be able to later in the trial if the defense can lay that foundation. And for that, I do think that the only way to do that is probably to have Ashley testify. Already, I figured that she was probably going to testify because she does have the burden of proving the affirmative defense of self-defense, but this does add to the need if the defense wants to get these messages in. Anyway, the other big issue here was that the defense wanted to get in through this particular witness the Cellbrite data about some of the Google searches that Ashley made in the weeks or months before the shooting. These searches apparently showed things like domestic parenting with an abuser, how to co-parent with an abuser, co-parenting versus parallel parenting with an abusive ex, and how to cope with parenting or co-parenting with an abusive ex. Now, obviously, the defense wants this in to corroborate this idea of her mental state, that it was such that in these private moments that she was looking for guidance on how to cope with DV. The issue with these Google searches was their admissibility, and specifically because of the rule against hearsay. So let's get into that really quick. Hearsay is one of those things that trips people up all the time. So let's try to break it down into pieces. For starters, here's the definition. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. It's a little complicated, so we've got to break it down for a minute. First, it's an out-of-court statement that someone in the trial is trying to offer up as evidence. Any kind of a verbal statement, a text message, an email, document, voicemail, all of these are going to be out-of-court statements. Google searches also qualify as out-of-court statements. Now, here's the part where people really tend to get confused. In order for the out-of-court statement to be hearsay, it has to be offered to prove the truth of the matter asserted. So to figure out whether the statement fits into the definition of hearsay, we have to understand why it's being offered in court. For example, if there's a text message sent from a husband to a wife that says, "You hit me with your car," what is the purpose of introducing that text message? That's a crucial question for admissibility here. Is it being introduced to prove the truth of the matter asserted? In other words, is it being introduced to prove that the wife actually hit the husband with her car? Or is it being introduced to show something about the mental state of the husband? For example, that he's hallucinating, or maybe he has dementia, because none of that ever happened. Or is it being introduced to demonstrate the effect on the listener, in this case, the wife, who might be thinking now at this point that there's something seriously wrong with the way that her husband's brain is working? All of this is really dependent on the circumstances of the case in particular. If the car hitting text is in the context of a case involving an actual automobile collision, it might mean one thing. But if it's a case about whether the husband had capacity to change his estate plans at the time that this text exchange happened, that is a totally different meaning for why this text is being introduced. So this is what I mean about context and the purpose of offering the statement into evidence. And so here in this particular case with the Google searches, there's this question of whether they are hearsay. And as a reminder, there are things like co-parenting with an abusive ex. Now, ultimately, Judge White found that these searches were not admissible because he couldn't see how they were offered for any other purpose than for the truth of the matter asserted. And so he determined that they were hearsay. And specifically, Judge White said that the truth that was being asserted here was the truth that she made these searches on this day. But on this one, I have to say, I think that Judge White got this one wrong. By his logic, none of the digital Celebrite evidence should have come in because the text messages that were introduced earlier were also offered to show that these messages were sent on the dates and times that they were sent. And respectfully to Judge White, I think this isn't a proper analysis of hearsay for these particular statements. When we are looking at the purpose for introducing the statement, we have to look at the actual text themselves, not the overall context of the message of it being a Google search versus a text message or something like that. So in order for these Google searches to be properly ruled as hearsay, it would have to be the case that the statements themselves, the words within the Google searches, would have to be offered for their truth. For example, how to co-parent with an abusive ex would need to be offered to say to the jury, see, Doug was abusive. These Google searches prove that. But that's not what the defense wanted the Google searches for. And I do agree with their stated purpose that they were arguing for. What they wanted them for was to show Ashley's mental state about her relationship with Doug and how she viewed Doug. So it's not so much about proving the truth of the words on the page, but it's about showing her own mental state. It's a different purpose entirely. Because remember, when it comes to self-defense, a massively important piece here is what her mental state was. And this is something that really kind of hits the center of the target, I think. So for example, proof that she was talking to people about the abuse is helpful to corroborate how she was viewing Doug as either dangerous or not. And so the same thing is true with these Google searches. So at the end of this exchange, Judge White kept these out, but I do think that this was a mistake. And to be clear, I don't think that this is an indication of bias by the judge against the defense. Rather, it's the case that no judge gets every single ruling right in every single case. They do make mistakes too. And here, I think that this was just a judge who interpreted things differently than the way that I would. And hey, of course, I think I'm right and he's wrong. Anyway, that was it for Sergeant Quiles because then the defense didn't have any more questions for him. So the state's 18th witness was Dr. Russell Vega. He is the chief examiner for the Sarasota and Manatee counties. And so he's the one who performed the autopsy on Doug after he died. And basically the important things that came out of his testimony are two main points: the details of the gunshot wounds to Doug's chest and the details of the gunshot wound to Doug's right leg. The easy parts of the testimony are that obviously Doug died from a gunshot wound. And Dr. Vega determined that the manner of death was a homicide, which basically just means that Doug died at the hands of another person, and the circumstances around his death don't suggest that it was an accident. Now for the part that is going to make more of a difference for both sides. Where were the entrance wounds for these gunshots, and what was the trajectory of the projectiles? On this point, first, Dr. Vega talked about the gunshot wound to the chest. He said that this gunshot wound did not have an exit wound, and he removed the projectile from the tissue in Doug's back. The entrance wound, however, is such a gray area that both sides are going to argue has a different interpretation. Specifically, Dr. Vega said that the projectile entered Doug's body on the right side of his chest and was somewhat located towards the front of the chest. Then the projectile traveled mostly side to side towards Doug's left side and traveled somewhat towards Doug's back. Now, the defense definitely wants to use this to say that she shot him from the front. This is because the best case for a self-defense argument involving a firearm is where the defendant shoots the alleged victim squarely in the chest and from close range. That's because this would suggest that the victim was moving towards the defendant in an act of aggression and that the danger to the defendant was very real because the defendant was within reach of the defendant. Now, on the other hand, the best case scenario for saying that this case was actually murder is the opposite, of course. The alleged victim was shot squarely in the back and they were far away from the defendant. The reason this helps a conclusion of murder as opposed to self-defense is because this suggests that the alleged victim wasn't in the process of aggressing the defendant, but rather retreating from the defendant. Even if the alleged victim had been following the defendant up to that point, if the defendant then reveals a firearm and points it at the alleged victim, and the alleged victim sees that and starts backing down, this is not a situation that's good for arguing self-defense. And so that's why these entrance wounds and trajectory angles make a difference here, as well as the presence of stippling. Basically, that's microscopic matter that comes from a firearm when it's been shot. And that's also why, in this case especially, this is a bit of a gray area. On the point of the stippling, this is essentially matter that shows up only if the alleged victim is within a certain number of feet of the defendant, or most specifically, the defendant's firearm when that trigger was pulled. It really can't say anything about what the distance was between them beyond that zone, but it does tell the jury if the alleged victim was very close to the defendant. And here, Dr. Vega testified that stippling usually is going to show up on the alleged victim's body if the alleged victim is within 3 feet of the defendant's firearm. And here, Dr. Vega testified that he found no presence of stippling on Doug's body. So this suggests that Doug was more than 3 feet away from Ashley when she shot him. Now, on the point of the entrance wound and the projectile trajectory, you have an entrance wound that really starts on the right side of the chest and moves towards the left. But at the same time, it shows that he also was faced somewhat forward towards the defendant. So the big question here is, what does this angle mean? I say it's a gray area because it really could mean two different things. On the one hand, it could mean that he's taking almost like a surfer pose to then leap forward towards her. But on the other hand, it could also be because in the moment that she shot him, he was instinctively turning away defensively, almost like cowering away from the gun. I can see both situations here, but what do you think? Let us know in the comments down below. Anyway, then Dr. Vega talked about the other gunshot wound. He said that this one was a bit more superficial, meaning that it likely didn't kill him. It was in Doug's right leg in the calf area. And the part that I find strange about this is that unlike the chest wound, which entered on the right side and moved towards the left, the leg gunshot was apparently the opposite. Dr. Vega said that it entered basically on the back side of the leg, and that the entrance wound was on the left side of the right leg, and that the exit wound was on the right side of the right leg. So in other words, the projectile entered through the inner side of his right leg and then exited on the outer part of his right leg. That, paired with the fact that it had an entrance wound more towards the back as opposed to the front, seems to suggest that this is an opposite path from his chest gunshot wound. And so this does suggest to me that Doug, around these moments, did in fact turn. But the question that I can't quite square at this moment is, what's the exact timing of the turn? Was he already in the process of turning when she started shooting him? In other words, was he turning to leave, for example? Or did his body turn in response to being shot? We don't get that much more clarity from Dr. Vega on this point, because he said that he can't determine which gunshot wound happened first, for example. And I should also point out that one thing Taylor said in the defense's opening statements is that Ashley, upon shooting him, apparently saw his legs fly up in front of him. And so the defense is suggesting here that the leg wound happened after the chest wound when his legs were up in the air. This would explain from a defense perspective how she was able to hit such a low point on his body while she was standing up. But the prosecution says the reason that she was able to shoot such a low point on his body from her stance is because actually in that moment, his leg was raised because he was trying to run away. So their perspective would be that the leg wound was happening first and then the chest wound happened afterwards. And the defense obviously says the inverse. Now, one thing that I will say is that Dr. Vega did testify that he said it's unlikely that a basic gunshot wound to the chest is going to cause a person's legs to fly up in the air in front of them, unless it was because they fell backwards over some kind of a piece of furniture or something. And here, there's no evidence to suggest that anything like that happened. And so I will say that the theory of his legs flying up does sound a little far-fetched to me personally, unless he had done something like maybe jumped in the moment before being shot. So all of this is a bit of a conundrum, and I think I'm going to need a little bit of time on this one, maybe over the weekend even, to figure out what it seems like is the most reasonable theory as to how these wounds ended up like this. But I'm really curious to hear what you all think, so let me know in the comments down below. Anyway, the state's 19th and final witness in their case in chief was Daniel Hausdorf. He is a crime laboratory analyst who works in the firearms section at the Florida Department of Law Enforcement, or FDLE. So basically, he tested the firearm to see if it was in working order, which he said it was, and he tested Doug's clothes for the potential presence of stippling. And here, like Dr. Vega, he did not detect any presence of stippling. And so he testified that with a pistol like the one that Ashley used, there actually are two data points to consider. First, he said that gun particles from the trigger pull will fall off around 5 to 6 feet. And second, he said that the vapors from the gunfire will fall off around 2 to 3 feet. So this seems to suggest that Doug may have been even farther away from Ashley, at least 5 or 6 feet away from her, extended from her firearm. Given his height, which was 5 foot 9 inches, this does seem to place him outside a space where he's able to leap forward in the moment to harm Ashley, unless in that moment he was already in the process of maybe rushing forward or running forward. But like I said, this one is very gray, and I'm curious to hear what you all have to say in the comments down below. Anyway, that was it for the state's case in chief. One thing that is curious is that the lead investigator never testified, which typically they do. This person is usually very helpful for the prosecution to be in a position to establish the prosecution's narrative of what happened, since they are the person who typically gathers all the evidence, and so they're able to sort of see everything and give a broader picture on the whole package of evidence, basically. And so I'm really wondering why the lead investigator didn't testify here. Maybe they found that it was just a little bit too cumulative, and so they didn't want to waste the jury's time. Or maybe there was something that was inconvenient for them that he would testify to. I don't know. Once the state rested, the defense got up to argue a motion for a judgment on acquittal. Now, if you've watched other trials with me, you know that this is an expected move by any defense team in a criminal case. And in fact, it's considered almost malpractice by many for a criminal defense attorney not to make the arguments for this motion before the defense moves on to their case in chief. Anyway, although it's typical for the defense to make a motion like this, it's also very rare for the defense attorney to actually win on this argument and to get this case dismissed at this stage. In order for the defense to win, the judge has to side with them after looking at the evidence in a light most favorable to the other side and while giving the other side all reasonable inferences. And in the process of doing that, for the defense to win, the judge has to then decide that the prosecution has not made a prima facie case. This means the judge has to say there's no reasonable jury out there in the universe that could look at this case presented by the prosecution and side in their favor. And this typically comes from the prosecution having some sort of a glaring error, some sort of a gap in their case that is so obvious that anyone can see it. And so this is a really tough standard for any defense to meet. And in a case where the defense has made an affirmative defense of self-defense, it's even harder because that's a situation where part of the burden has shifted to the defense to prove their affirmative defense. And that typically happens in the defense case in chief. And so here, it's no surprise whatsoever. The defense denied the defense's motion, and on day 4, we will then see the beginning of the defense's case in chief. So in the morning, the two legal teams are supposed to be going over some other housekeeping matters. The testimony should continue in the afternoon of day 4. But then at the end of the day, during all of this discussion, the defense also suggested that they may be able to finish their case in chief by the end of Tuesday, in which case closing arguments would be on Wednesday. So this has been a pretty fast trial in comparison to others that we've seen. And personally, at this point, I still feel like I'm somewhat down the middle on how I think this will result. I might need to think on this one over the weekend, especially after Dr. Vega's testimony, because there is quite a bit there to consider. But those are my thoughts. What do you think? Was there DV? Was there not? Has there been enough of a showing that she was in reasonable fear for her own life in the moments before she pulled the trigger? What do you think about Doug's positioning by the trajectory of the bullets? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily recaps of this trial or more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you're really loving the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can either join through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you on day 4.